So good morning, everybody. Thanks so much many of you joining us this morning. So I'm joined by Alice Reeve, who's a fellow partner in the employment team, to talk to you about some of the holiday pay issues that have risen following the Supreme Court decision. I've also got with me Jessica Scott-Dye, who is our PSL, and Jessica's been helping us in the team digest the implications of the Supreme Court decision in Brazel and work through the implications of it. Jess's role today is to help us with the Q&A and the questions. So if, as Jess has said, if you do have questions, please put them in the Q&A as we go through. We'll try and then summarize the questions at the end where Jessica will help us. If it's a straightforward answer, she may well be able to pop a response in the Q&A box as we go through the session, but largely we'll look to try and pull the themes together at the end, and Jessica will help us talk through those questions as we go. The starting point is to just set the scene and give you some background as to the Supreme Court decision and the holiday pay rights in the UK. We'll then briefly look at the decision in the case, and then also look at how they then apply that in relation to holiday pay calculations, the impact of the judgment on maybe working practices or issues you need to manage in your workplace, and then some strategic considerations about how you actually go about dealing with these issues and looking to implement the decision. So moving then to setting the scene, as I'm sure you're familiar with, our holiday in the UK is largely based on a statutory entitlement. Obviously, you may have a contractual entitlement that enhances the statutory entitlement, but the starting point is that the statutory holiday arises from the working time regulations, which in turn implements the working time directive. So under Regulation 13, everyone, if you like, gets 4 weeks holiday by way of the European working time directive. In the UK, we then enhanced that in the working time regulations and essentially added in the statutory holidays, the bank holidays. So the entitlement in the UK is 5.6 weeks pay. And that entitlement is an entitlement to be paid holiday at a week's pay, and the calculation of a week's pay is done by reference to the provisions in the Employment Rights Act about how you look at pay. So just to try and put it in context, if you work full-time or part-time and you work all year round, and you then take a holiday, then your week's pay will be for a calendar week's leave. So for example, if you work full-time and £1,000 a week, then you'd be paid £1,000. You're taking your holiday for that week that you've taken as holiday. If you're part-time and you let's say earn £500 a week, and when you take holiday, you would receive £500 a week for that holiday. So in that sense, nothing has changed. But where the rules start to get more challenging, and where the Supreme Court was looking at the issue, is those who work a part year or have an irregular working pattern or work on a casual basis. And it can sometimes be difficult to establish exactly how you approach that holiday entitlement, hence the litigation that we've seen. So moving on to the next slide, in terms of trying to address how holiday entitlement should be paid, there have been various approaches over the years, and these were discussed at length in the Brazel litigation, and we'll come to the outcome in a second. But just as a refresher, because you might be familiar with some of these, previously employers have looked at the percentage method for calculating holiday pay, and this is where, if there's no normal working hours, you look at whether holiday pay essentially accrues at the rate of 12.07% of the hours actually worked. So the way in which you get to that is that a standard work year is 46.4 working weeks if you work throughout the year, 52 weeks in the year minus the 5.6 weeks holiday. And then the 5.6 weeks is viewed as basically 12.07 of that 46.4. So on that basis, can you apply that percentage to the hours actually worked, give you pay? That was quite attractive to a lot of employers, and in fact ACAS and BASE recommended it in their guidance previously, before this litigation got into the more senior courts. That guidance was then taken down. Another approach that some employers have taken is the pro rata principle. So basically you look at prorating holiday pay on the basis of the work pattern. So again, if you've got 46.4 working weeks in the year, if you work full time, let's say someone rather like Brazel, Mrs. Brazel, was working 34 weeks of that she was in a school environment, so in a school year. So 34 weeks over a maximum of 46.4 is potentially 0.73% of 46.4. So do you then apply that 0.73% to the 5.6 weeks entitlement? And if you did that, you might say that Mrs. Brazel is entitled to just over 4 weeks paid leave. Yeah. So these various ways of doing things have been challenged because people who work irregular working patterns have felt they weren't necessarily being paid fully for their holiday pay. And if we just go to the next slide, you'll see that they've been resolved by the Supreme Court in terms of the fairly narrow principle as to how you go about looking at holiday entitlement. But that then has raised a number of questions which we'll look at going forward. So in the Brazel judgment, the Supreme Court's view was that regardless of your working pattern, if you're employed throughout the year, then you're entitled to 5.6 weeks statutory holiday under our working time regulations. And the way in which you calculate those 5.6 weeks holiday, the pay for that holiday entitlement is to use the weeks pay provisions of the Employment Rights Act. And there is no mechanism for you to look at as an employer reducing holiday entitlement or prorating it to take into account that someone is working a part year or is working on a casual basis. If you are employed throughout the year, the entitlement is 5.6 weeks, and you then have to apply the statutory rules about how you calculate a week's pay. And this is where, if you like, the fun starts and the difficulty starts in terms of feeling that you've got to a sensible position with your employees who work part year or work on a casual basis. So on that basis, we're going to start to look at how you would actually calculate holiday pay, and Alice is going to pick up on the next slide.
Thanks very much, Gareth. Yes, having established the principles, we're just going to drill into that in a little bit more detail. First of all, looking at what that actually means in terms of establishing that you've paid people correctly for their holiday. So we now know that everybody who works all year round is entitled to a minimum of 5.6 weeks off. And in terms of off with pay, and in terms of what's paid, that's got to be at a normal week's pay for that 5.6 weeks. So the basic principle, as Gareth said, is that everyone who works all year round has 5.6 weeks times by a normal week's pay in which they can be away from work. So it sounds simple. It's only when you start applying it to different categories of staff that it becomes more complicated. So looking at how you calculate that week's pay and demonstrate that everybody is getting what they're entitled to, that is set out in statute, as Gareth said, and nothing straightforward in that there are 4 different categories of staff, depending on how they work their hours and how they're paid. So we're going to go through each one, and you will need to look at your workforce and work out which category they fall into and make sure that the way in which you calculate a week's pay for their leave is correct in accordance with those statutory requirements. So the first category on the next slide is for those staff who work essentially standard hours, albeit for part of a year, and they get a set amount of pay for that. So the classic example, I know we have got some people here from education organisations, would be, say, your teaching assistants who work 32 weeks a year, and they're paid a set rate for working 30 hours a week for each of those 32 weeks. So it's anybody who has a set number of hours and receives a set amount of pay for those hours is the first category. For those members of staff, the way in which you calculate, could you just flip back? For those members of staff, the way in which you calculate that is that they must just receive their normal week's pay for each week of that 5.6 weeks leave. So sorry, just moving then on to looking at how that might work in practice. Often for those individuals, they work, say, a set number of working weeks a year, so maybe that's 32, and then they have their holiday weeks added on to that, and then it's averaged out. So yeah, using that example, if they work 39 term time weeks a year, for example, then they're entitled to be paid an extra 5.6 weeks in respect of that holiday entitlement. So overall, they're entitled to receive payment for 44.6 weeks a year, and then they often receive that averaged out in an annualised salary across the year. So that will be a significant category of staff who are affected by this decision. Anyone who works, who's got a contract that essentially spans the whole year but only works for part of it, you need to look at using that method of calculation, and that they're getting those 5.6 weeks included in their annualised salary. There's one extra sort of complication for these individuals, which is around overtime and how you pay overtime. And so the principle in law, if you just flick on to the next slide, the principle of law is that if overtime isn't part of their normal week's pay, normal remuneration, then you don't need to worry about it. So if essentially somebody's off sick, somebody steps in and does a bit of overtime, but it's unexpected, they wouldn't usually get overtime, or that it's just very ad hoc, you don't need to worry about it at all. You can just use their normal week's pay when doing the calculation. But we've had a string of European case law that said essentially there must be no barriers to somebody taking their week's leave. They must be paid the same as when they're at work as when they're off. So if you have individuals for whom it is a usual part of their working life that they work overtime, if you said, oh, do these individuals work overtime, and they would all say yes, and you as an employer would say yes, then you do need to make sure that the payment they get for that overtime is included in their holiday pay calculation. And so there are a number of ways in which you might do that, and we can perhaps look at those later. Again, to make it a bit more complicated, it's not the whole 5.6 weeks technically, it's the first 4 weeks, as Gareth explained, that were derived from the European leave directive. So actually, again, if as an employer you're looking at paying a supplement in relation to people who work regular overtime, you could choose to just do 4 weeks worth, again depending on how straightforward that is, but that's the technical legal position in relation to those individuals. The second category of staff is one that I don't come across much in my working practice, is when individuals do piecework. So often this will be individuals who are involved in production, and they get paid depending on the output that they are achieving, so the amount of work done. For those people, they're still entitled to 5.6 weeks off, but in terms of calculating their normal week's pay, you need to look at their normal working hours and then times that by their average hourly rate of remuneration. So again, so you're getting the average over 5.6 weeks. That's similar to the third category of individual, where they work shifts, or where their pay varies with the work done, or as to when the work is done, sorry. So the classic examples of that are if people paid more to work at weekends or night shifts, or at different times of day. You need to look at, in terms of calculating their week's pay, you look again at their average normal working hours and then do the average hourly rate of remuneration. So you're averaging it to capture the average based on the different shifts that they may work. So you may have staff in those categories depending on the type of employer you are and how you engage with individuals. The fourth and final category is again one that comes up a lot, which is where staff essentially have no normal working hours. So typically on either 0 hours or variable hour contracts, where there's no necessarily guarantee of hours that they work, and it varies over the course of a year. So in relation to those individuals, again, they're entitled to their 5.6 weeks off, but in terms of calculating how much they're paid for those 5.6 weeks, again, it's an average. And to do that average, you need to take into account it's an average over the last 52 weeks in which they've received pay. So if they worked every week in the last 52, you would divide it by 52. But if actually there were weeks in which they didn't get paid during that period of time, you need to go back and count the weeks that they got paid up to a backstop of 104 weeks. So over potentially going back 2 years to get that 52-week average. If you don't have 52 weeks in that period, so they've only worked a few weeks a year, you just need to use it based on the number of weeks that they've got paid, so you get the average weeks pay. And again, obviously you times it by the 5.6 weeks, so they get their 5.6 weeks off. I appreciate that some of those calculations may feel a little bit dry out of context. We're going to look at the impact of the judgment in more detail and how that might apply to the categories of staff that you have in your workforce as well. But we thought it was important to capture in the slides the methodology of the calculations. So I'm going to move on to look at actually the impact of the judgment and a few of the questions that we have been asked, and then Gareth and I are going to then look at what that means in your organisation and what you need to be thinking about. So the $1 million question really, can we prorate statutory holiday entitlement for part-time staff? Well, there's two parts to that. The answer is you cannot any longer prorate statutory entitlement for people who work part year. So you can't prorate the 5.6 weeks. Everybody is entitled to a statutory minimum of 5.6 weeks annual leave. Of course, actually, in terms of what that means in practice, it is at a normal week. So if you're giving someone a holiday allocation, actually, if they only work part of a week, they're not entitled to the same actual amount of holiday as somebody who works every day in a week. So by way of example, on the slide there, if you work full time and you work 5 days a week, your 5.6 weeks equates to 28 days leave a year. If you work 3 days a week, your 5.6 weeks equates to 16.8 days a year. So the law does still enable you to prorate based on how much somebody works in each week. It's just that you can't do it based on how many weeks they work in each year. So, so again, when they've got that holiday allocation, it clearly applies. In addition, if actually you're incorporating it in their pay, like we talked about for, say, the term time only staff, because the week's pay is based on their normal week's pay, if someone only works 1 day a week and they're paid for 1 day a week, essentially that's included, so they get 5.6 weeks at that 1 day a week. So actually it does prorate based on the amount they work in each week. So so being really clear, you can't prorate the statutory entitlement below 5.6 weeks in each year, but you can but actually 5.6 weeks does take into account how many weekdays they work in a particular week. So there is a prorating still in place technically for that. So the next question, which we get asked, is whether you have to whether this principle also applies to contractual holiday. So we know that the Brazel case concluded that you couldn't, there was no principle to prorate statutory 5.6 weeks leave a year. That principle does not apply to contractual holidays. So if you are an organisation which has has over and above the 5.6 weeks entitlement for your full-time all year round staff, say 6 weeks or 7 weeks, you can prorate that then based on the proportion of a week that someone works, but it's subject always to the minimum of that 5.6 weeks a year. So it's worth doing that sum to make sure that you do understand the fair proportion and that your part-timers are getting a proportionate share of the full-time holiday equivalent, but it's always you've got to always ensure that it doesn't fall below that 5.6 weeks in any year. And so as well as obviously part-year staff, the variable staff is an area that has prompted sorry, I missed this question. If you're work for more than one. Hold on, no, sorry, can you flick on to the next slide? That's my fault. So another question we've been asked quite a lot over the last few weeks is what happens and how does it work if you have somebody who works for more than one employer? Often casual staff have more than one job. Well, the principle is that for each employment, they're entitled to 5.6 weeks off, but obviously that's based on their pay for that period of time. So using this example, if they have one employer where they work 3 days a week and one where they work 2 days a week, in each case, they're entitled to 5.6 weeks off at 2 days a week and 5.6 weeks off at 3 days a week. So, or if it were paid as part of their pay, they would be paid the 2 days a week at 5.6 or 3 days a week at 5.6. So yeah, it adds up and they have 5.6 weeks for each contract of employment. So I was hasty, I was going to move on to look at variable hours, which is the next one. So yeah, casual staff and variable hour contracts is an area where this judgment has huge impact because so many employers have staff who are on sort of 0 hours or variable hours or flexi, atypical working arrangements. And as Gareth said, I think almost every employer that we worked with used a percentage in terms of paying for the holiday because it was just a pragmatic and an easy and straightforward way of ensuring that individuals were paid for some holiday. And obviously they don't work, most of the time they don't work every week of the year, but we know now that that's not possible. So you do need to look at those categories of staff and think about what kind of contracts you've got them employed on and how you currently pay it and unpick some of those arrangements. So we're going to look at that in a little bit more detail going forward. So we're going to look now at the strategic considerations and the things that you need to think about to implement the judgment effectively. And so there are really 3, maybe 4 main things you need to do. First of all, you need to think about your contractual wording. And so you'll need to think about what your contracts say on are they compliant with the law as it now stands. You'll need to think about that, of course, for new staff. And you'll need to also think about your existing staff and whether, I think for most cases, you won't need to reissue new contracts for existing staff, but you can provide a letter of variation if you need to think about going forward. In addition to thinking about the contractual wording in itself, you'll need to think about the methodology in terms of how you calculate their holiday and whether that is correct. And so, for example, it may be that your contractual wording is okay, but in fact you have not been paying the 5.6 weeks holiday in terms of calculating their annualized salary. And so you'll need to look at that methodology and how to capture that as well. And again, you'll need to then think about how you correct that for your existing staff or how you correct that going forward. And then also thinking about arrears as well. And so we're going to look at each of those issues. And once you've established which staff affects and the implications in terms of the contracts and the pay that they're going to receive going forward and they might be entitled to going back, you'll need to think carefully about how you communicate with staff. So we're going to look at each of those elements. I'm going to just look at contracts first before handing over to Gareth. So in terms of what your contracts say, again, go through, I'd recommend that you do an audit in your organisation. You may have already done that because we've known this has been pending, but look at the different categories of staff that are likely to be affected. And so, as you'll see from what we've said today, it's going to be anyone who works part of a year and whose pay is referenced to, and their holiday entitlement is paid with reference to part of a year, or anyone for whom they receive a percentage holiday entitlement. So go through and establish, first of all, the categories of staff that you've got that are affected, and then look at the contractual wording. make sure it's really clear in the contracts. There's a requirement that they understand how much holiday they get and how that holiday is paid. So make it clear that it's subject always to that statutory minimum of 5.6 weeks. Again, if you only pay 5.6 weeks holiday for all your staff, then you may just want to state that it's 5.6 weeks for everybody. If you've got something over and above that, as the full-time all year round equivalent, you may want to be clear that that can be prorated, but subject always to that statutory minimum of 5.6. That 5.6 weeks includes bank and public holidays. So again, think about how that works in practice and with your contracts, and that can be inclusive. You do need to ensure you're doing comparable treatment for full-timers and part-timers, and they're not less favourably off. So just be careful about that. But just make sure you understand and how that's reflected in the contracts as well. Again, for those people who are paid an annualised salary and don't work for part of the year, make sure that they understand how their holiday is calculated and included in their salary. So we would usually expect that in the salary clause, you state, for example, you're paid for 34 working weeks a year plus 5.6 weeks holiday weeks, and that's how your annualized salary is calculated, so they can understand their holiday pay calculation. For those who are on those hourly paid or irregular hour staff, consider what you do at the moment, and whether you've been paying them month to month, the percentage of holiday, or whether you pay them at set times a year. You will need to now think, that 5.6 weeks, when do they pay them, and on that, and make sure that the contracts are clear and it's reflected and that everybody understands when they're going to get their holiday pay. So I would be surprised if your contracts don't need amendment. I would think that most employers do need to look at their contractual wording. I'm going to hand over to Gareth now, who's going to pick up and look at some of those points.
Thanks, Alice. And yes, so we're just going to just in terms of strategic considerations for a few minutes, just look at what you might want to do going forward to implement the decision, and then also just look at the implications in terms of looking backwards and whether there are arrears of pay, as well as then maybe looking at how you structure the workforce. So as Alice has introduced, obviously looking at holiday pay going forward, you'll need to look at your contracts. It may well be that on a review of the wording is fine, but it's how you've implemented it. So there are two strands to it. It's, do you need to amend your contracts, or do you need to issue a variation letter, or is it that you actually need to review your calculation practices that sit behind the entitlement that's in the contract, and that's maybe what needs review. Obviously, lots of employers are worrying that the decision means that they're paying more for holiday pay, and it's increasing operating costs in another area, and we're all under pressure in terms of increases in costs. And it may well therefore be, as part of the review going forward, you're looking at whether you use discrete contracts at particular times for engaging staff, and you don't have people employed all year round, albeit on a variable basis. And whether you might want to reduce your use of term time only contracts going forward, and can others work for you on a different basis. And if you are looking at pay reviews, whether, again, as part of the overall calculations, you look at how you can incorporate any additional pay, holiday pay, into that pay review, so you're not potentially paying twice or adding to the bill on 2 occasions. So can you be coordinated in how you do things? And ultimately, if there is an increased cost, then depending on which sector you're in and how you operate, whether there is savings you can make elsewhere or costs that you need to pass on to others in order to save any increased costs. So just looking at the next slide then, taking that forward, thinking about when you will pay your holiday pay. Obviously, for those who've got annualized hours, as Alice was saying, it'll be paid as part of your regular monthly salary going forward. So either the calculation is correct, or it might need some modification to take into account the 5.6 weeks, and then you'll be able to inform people going forward what their holiday pay is. The staff whose pay varies, or they don't have normal working hours, then it may well be that you need to decide on a payment schedule, and it may well be you want to carry on with your existing practices but amend the amount that's paid, or you may want to look at whether you change your practices in terms of when you will pay. So just flipping on to the next slide. Some of the considerations in relation to that come from case law. So, for example, the principle in case law is that you should pay holiday pay when the holiday entitlement is taken. But those who work on a, for example, on a term time only basis, would it therefore be the case that you will pay a proportion of holiday pay at the end of every term, for example? If you were to do that and to essentially pay the holiday in tranches, then bear in mind that a week's holiday entitlement, the holiday pay, is calculated by reference to a week's pay over the last 52 weeks. And so you're going to have to refresh the calculation every time you choose to pay holiday. So there are a number of factors that you just need to balance in terms of how it is that you look to then pay out on the holiday entitlement. And that may lead you, in terms of obviously increased admin and the way in which you look at things, just moving on to the next slide, to actually consider different working patterns. So I think lots of employers these days have some form of casual help and able to call on additional resource. We talk a lot about a gig economy and how we look to flex a workforce. But ultimately, how are those casuals engaged? If they're engaged on essentially a whole-time contract, as in they're always the same contract and you just then draw the time off, is that the most appropriate way to go forward? Would you want to look at maybe having further short-term, fixed-term contracts be appropriate? More admin with that. There's more need to be on top of the paperwork in terms of issuing a contract and then being very clear that when a period of employment has come to an end. But that may help in terms of managing some of the issues if you've got the resource to do that. An alternative approach may be to look at an umbrella contract of employment, which sets out the terms that apply, but also makes it clear someone is only actually in employment when they have work to do on an assignment basis. They can be tricky again to manage in terms of the paperwork can be clear, but then it's how it's implemented in practice as well. So there will be some training of managers and you need to think through some further issues as to how you maybe implement that. And some employers are talking to us about whether they actually look at restructuring and maybe have less reliance on casual staff. So if you have particular tasks that need performing during the year and you currently rely on casual staff in relation to that, do you move away from engaging with those for those tasks? So, for example, in schools environments, exam invigilators may only be engaged at certain times. Do you move away from that and do you ask other staff to invigilate your exams with regard to people who are already employed and who can vary that hours? So a number of considerations going forward in terms of how you might structure your contracts and how you might respond to an increase in holiday pay, in holiday entitlement and therefore holiday pay, if that is something that concerns you in your workforce in terms of how the increased cost factors through. That's looking forward. We thought we'd just also spend a moment looking back. So if we just go to the next slide, obviously one of the other considerations in this decision is, have employees been receiving the right level of holiday pay so far? So obviously it will be helpful to look at what the current calculations are. Have you as an employer relied on a percentage basis or a prorated basis, as we started the session with? Again, what does the contract say in relation to entitlement? And when you redo the maths, depending upon how that person is paid, the level of work they're doing in their remuneration, have you got a minimum wage issue, national minimum wage issue in relation to the proper pay for the job once you factor in the paid holiday entitlement? So looking backwards, you maybe have a bit of a checklist of things to review as to working out what it is that you have paid and what the difference or gap is between that and if you were doing it as the Supreme Court has now said you have to in terms of recognising the 5.6 weeks holiday entitlement for those who have continuous employment. going on to the next slide, if there is an underpayment, then obviously you just need to consider how you're going to manage that. You may decide to do nothing. You might just recognise that there is a shortfall, but you're going to be positive about correcting it going forward and leave it at that. You may well have to get into more detailed discussions with staff who've read about the decision, who are raising issues in terms of how it's paid. And also, obviously, you're looking back at pay records. There may well be some discrepancy. Have you got the information on your payroll? Are you able to answer the questions? Do you need to do some more work or interrogation of your system? So you're ready to have the conversations when you update some staff on basically how you're going to deal with holiday pay going forward. If you are looking at underpayments and looking at periods going back, then it's important just to also consider the period at which you have to do that. So if we just flip on to the next slide, when you're assessing arrears and back pay, then we back in 2014, the government recognised, you may remember some other holiday pay discussions around whether you include commission or overtime, as Alice was outlining earlier. They led the government to look at limiting the amount of back holiday pay that could be claimed as a lawful deduction from wages as a 2-year backstop. That was introduced in 2014. So if there's been a series of deductions, if they're broken for a period of time because someone and that period of time is at least 3 months, or if someone's actually paid the correct amount, that potentially also breaks the series of deductions, then it may well be that deduction also helps you in relation to the amount of time that you have to look back from today in relation to how much holiday pay arrears have actually accrued. In terms of looking at the series of deductions rules, it is also being litigated. So we just flagged on the slide that if you're going to go down that route, then just understand where the challenge can come from in relation to scrutiny or litigation in relation to that. But at the moment, absolutely, it is something I want to think about in terms of how someone's being paid and when deductions actually could be challenged under the deductions rules. So just moving on to the next slide. Obviously, there's a certain amount of commerciality you may look at in relation to recognizing there's an issue, but how do you actually deal with it? Do you go back and do individual calculations, depending on the number of people you have on who are affected by the decision? That may be a fairly onerous task. Do you try and take some averaging of where you think holiday pay was and what holiday pay should be, and you come up with a figure that you're confident at least deals with the statutory minimum and basically buys out claims? Or do you just say, this is the system going forward, and you're going to offer everyone a lump sum payment to deal with any discrepancies going backwards in the same amount, especially if you've got categories of people with similar working patterns and similar time work? It is something I think very much it will depend on your workforce and on the size of the issue for you as to how you approach it. And it may well be you'd want to do a bit of a straw poll with regard to doing some size calculations and then looking at whether you can extrapolate that out over a wider group of employees. So just moving on to the next slide. And you then obviously at some point employees may be asking, but you may also want to reset the position. As we've said, obviously you have to be clear about holiday entitlements and how it's paid, so you are going to have to communicate with staff if you do need to make a change. And in doing that, I think it's useful to have thought through what it is you're going to say to staff in terms of the change going forward and explaining any changes both in terms of holiday entitlement accrual, so any contractual change, and as Alice said, do you need to reissue contracts or can you have a variation letter which is sufficient, give clarification? Are you going to make a payment at that point in relation to arrears, or are you just going to tell people the good news that you've taken into account the latest Supreme Court decision and holiday pay going forward is calculated on a revised basis, which you then set out and go forward? It's worth bearing in mind that if you correct the holiday pay issue and start paying at an enhanced rate that avoids any arguments about there being a deduction, then obviously there is a period of time running, again, the 3 months is running from the date that the correction has been paid. So some employers are looking at absolutely being positive about it, adopting the principles in the Supreme Court decision, communicating positively with staff about future change, but then very much leaving it for staff to raise any issues about back pay or arrears where they think things have been wrong, and putting the onus on the staff to essentially say what their calculations they want the employer to take into account. Our experience so far is that whilst it's an issue that's been talked about a lot, calculating holiday pay can be difficult and tedious, and if you put the onus on the employee to do so, then they may well decide it's actually not worth pursuing, and they're happy that an employer has embraced the decision going forward, and that remedies things. But obviously those who feel particularly strongly about it would then have a route through to raise the issue and to look at it. So again, I think thinking about how you're going to deal with arrears as well as going forward and having a joined up strategy is important then as to how you communicate with staff, what the messages are, and the level of pay that you're offering going forward. That concludes our strategic considerations review. I can see the Q&A box has been ticking up with regard to a number of questions that we prompted as we've been speaking. So I'm hoping Jess and Alice can now join us, and we can look at some of the themes and questions that you've asked, and do our best to answer those on a thematic basis or a specific basis, Jess, depending upon the questions that you've got.
Thank you, Gareth. So something that has come up a few times is the practical approach if your holiday entitlement is, if you've got contractual holiday entitlement in excess of the statutory minimum. So how do you deal with the statutory element and then the contractual element going forward?
Do you want me to pick that up and Gareth chip in? So I mentioned this, that technically this case law applies to the statutory element, so it's the working time, 5.6 weeks. So you then, or the overbid of law is the part-time worker regulations, and you need to make sure that your part-time staff get a prorated equivalent to your full-time staff. And so you've got those two principles that apply. So what that means in practice is that you potentially can prorate your contractual entitlement as long as it's a fair prorating, but it's always subject to that statutory minimum. So I'll just give you an example. Let's say as an employer, you have 7 weeks contractual holiday entitlement. So that would mean that for an all year round person, they would be entitled to 45 working weeks plus 7 weeks holiday. If you then had somebody who worked 38 weeks a year, if you do that sum of 38 weeks out of 45 weeks, so that's the percentage of the working weeks that they work, technically their holiday entitlement then is 5.9 weeks. When you look at 7 weeks being the all year round equivalent, so you should make sure that they get their 5.9 weeks. If, however, say you've got somebody who only worked 34 weeks, when you do that sum, 34 weeks over the 45 weeks to work out the percentage times by 7, you get 5.3 weeks, and that needs to then be rounded up to the minimum of 5.6 weeks. I hope that makes sense.
Thank you, it does. And I think just to add to that is just to make really clear distinction between prorating that contractual element of holiday and holiday pay versus capping holiday pay for your part-timers or your part-year workers to statutory holiday only. So those are two different things. And if you cap your holiday entitlement to the statutory entitlement only, and you give your year-round or full-time workers an additional contractual entitlement, that's when you risk getting into murky water around your fair treatment of part-time workers. So I hope that's clear. So there's a distinction between prorating holiday and capping holiday when you're talking about a contractual element of pay. The other question we've had a few times is on rolling up holiday. pay. Alice, it's probably another one for you, I think.
Okay, but feel free to chip in, or Gareth. So yeah, as I mentioned when we're speaking, I think it had been a really common practice, and in fact in line with the ACAS guidance, where you're working variable hours, to essentially give somebody a percentage, you know, be that 12.07% or a higher percentage for each hour worked. And the concept of rolled up holiday pay had actually been precluded quite some time ago in a line of case law, but because that case law essentially also said, though we don't think we should roll up holiday pay, if actually as a matter of fact you can absolutely demonstrate that somebody has been receiving their holiday entitlement and they have also had the equivalent time off, any monies that have been paid to them will be set off any claim. So lots of employers took a view that the risk of using that sort of added on to the hourly rate was quite minimal if it was really clearly split out, say in their pay slips, and you could demonstrate that they were receiving it. That has now, I mean, the difficulty now under the new Brazel decision is that it is really quite difficult to demonstrate that if you are working an hour and getting then a percentage, how that doesn't really equate to having your 5.6 weeks off each year paid at your average remuneration. So our advice, I think, would be that you should look at moving away from the sort of adding it on to the hourly rate, rolling it up methodology. Obviously, that will require some, although actually staff may be better off, it will require some clear communication with them as well. And actually they may like it less if they've been receiving it months to months to months, to suddenly having it, you know, at spells in a year when they are actually on leave. So you will need to think about how to do that. And Gareth touched on some of those points in terms of thinking about whether you might pay it in, you know, broken up across the year, say a couple of weeks at Christmas and Easter and in the summer.
Thanks, Alice. Another theme that is coming up quite a lot is when we've got irregular hours workers, it's difficult to know how many hours actually equates to a week off. And I know this is something that we've considered, and I wonder if it's worth just going into, you know, the extent to which we might want to control how holidays taken in the contract to mitigate that.
Yeah, again, sorry, it feels like they were all in my section, but Gareth, I'm very happy that you should be.
I'm equally happy you're answering them, Alice. Go for it.
I always think of, you know, in my head, I always do think of it as somebody having 5.6 weeks, and that's paid at their normal week's pay. And I think that is much easier than sort of conflating the two concepts. So it's 5.6 weeks calculated an average. As Jess said, you know, how does that work then in practice when it rolls out? I think if you've got people who are genuinely casual, probably the easiest way is to nominate times in a year that they need to take that 5.6 weeks holiday. So you may say that they only work when they're required to work, and they've got lots of periods of time when they're not required to work. But they also in each year get 5.6 weeks holiday. And so using that example, you might, there's no hard and fast rule as to how you divide it. You might do it in equal installments. So dividing 5.6 by 3 and paying that in 3 installments at Christmas, Easter and summer, for example, or you might pay it in 2 blocks or whatever. So I think that is a more straightforward way of doing it, to say, you know, you work when you're required to work or you agree to work, but then you also get 5.6 weeks of holiday. And we'd expect, for example, you might say you take 1.6 weeks holiday at Christmas, and so that then you will know that in the December payroll you need to do the sum of 1.6 weeks multiplied by their normal average pay going back over that 52-week average, and they get that extra payment of 1.6 weeks at Christmas. And then you also do the same, so they're 1.6 weeks at Easter, so they're off for 1.6 weeks at least, might be longer than that, but they receive that payment at Christmas and Easter, and then the balance of 2, not done the sum properly, 3 weeks at in the summer holiday. So essentially splitting up that 5.6 weeks and being specific in the contracts about when the holiday falls. That seems to be a way that means that you can manage that as an organisation, and that actually you're not just down to when individuals taking their holiday entitlement at any point and them then having to do the sum at each time as well. So that does seem a sensible way of managing it, but you might want to take some specific advice on your own working arrangements.
Thank you, Alice. A more general question that's been asked a couple of times is maybe we can talk about whether this Supreme Court judgment can be appealed any further or whether the working time regs we think might be amended or not. If there's any views on that.
I think the Supreme Courts were clear on that. They based. I don't think the decision will be appealed again. It can't be. There's nowhere else to go. It is our Supreme Court. So the end of the line. But the Supreme Court did recognise that there may well be imperfections in how the working time regulations are drafted, but that's really a matter for government as to whether they then look to review the holiday pay arrangements that we have and look to issue new regulations or new guidance. And obviously there are various other cases over the years that have flagged where our working time regulations around holiday pay are not particularly helpful, that don't really reflect how people work these days. So I think it will be something that will go on a list for government to review, and in the meantime we are stuck with what we've got and we have to make the best of it to work in terms of the working practices that the employers want to use, and some of the probably increased admin and calculations that Alice is just talking about, then if you have got casuals or others who have a sort of not a regular working pattern.
Yeah, thanks, Gareth. In the judgment, the Supreme Court described the ruling as a slight favouring of workers with highly atypical work pattern, and we've considered that statement quite a lot, in that we think actually it's clear that the implications of this judgment go much more widely than just that kind of narrow assessment. But as far as we're aware, the full implications haven't been picked up kind of by government. There's been no announcement about any response to this. So as far as we're aware, this is the position, at least for the time being. How many more minutes? We've got a few more minutes. We've got a couple of questions on if people have got more than one job, how is holiday entitlement worked out? So if somebody works 2 days a week in one job, 3 days a week in another job, does that impact the holiday entitlement? How does it work?
The short answer is it doesn't, although Alice, it's one of your slides, you want to talk to the detail of it, but basically both jobs carry an entitlement of 5.6 weeks holiday entitlement. Obviously the arrangements within that in terms of how you then calculate a week's pay will differ for the two employers, but essentially if that person was to take a week's holiday, presumably taking holiday for both, and it would even out to they're still getting the same level of calendar week's holiday. The issue will be what they're paid for that in relation to their two employers. Alice, anything to add? You looked at that.
No, I don't. I was going to suggest, Jess, that we might just pick up the point around working all year round, because that's come up a fair bit as well.
Yeah.
You're happy that I picked that point up?
Yeah.
So yes, this judgment only applies where somebody has got a contract of employment that works that spans a year, or contract to work personally over a year. So if somebody is employed under a contract for less than a year, then you can still prorate the holiday entitlement based on the proportion of the year that they've worked. So that the reason for that is under the working time regulations, the first year of employment and the last year of employment both have prorating provisions. So you can do that where if someone's working less than a year. So we saw, we have had lots of those absurd questions of, taken to its extreme, someone who works 1 week a year is entitled to 5.6 weeks holiday. Yes, that's true, only if they are employed under a contract which spans for the whole year. But if you employ them just for 1 week, then they just get the amount that's prorated to that week. So I think it is important to understand that principle, and it will drive how you think about engaging with your staff, as Gareth talked about. So do think about where you've got people on these overarching contracts and whether it's better to use fixed term contracts. And I saw a question where somebody got a model where they were sort of on a bank, and actually you could argue that the contract to perform work was only when they were offered work and accepted it, an assignment model. Again, that potentially is a viable option, and again you would then pay them their holiday entitlement on a prorated basis at the end of each assignment that they'd worked. So if you have got people who are only working for very short spells in a year, there are definitely models that may work better for you than having them employed all year round. Subject to the admin, you've got to do that cost benefit with the admin, but it's worth looking at.
Thanks, Alice. We've got a couple more minutes, and another question that is coming up quite often is whether people can be paid in lieu of holiday, and when they can be paid in lieu.
The short answer is you can't be. It's a statutory entitlement, but in the year that you are leaving, yes, if you haven't used your holiday entitlement, then you can be paid in lieu. And I think that probably feeds into Alice's last answer about people who have short-term assignments then receiving a payment in lieu of their holiday entitlement at the end of the assignment if they haven't taken holiday during it.
Thanks, Gareth. And do we have time for one more very quickly?
Go for it.
Leavers. So we've talked about the limitation periods and the approach to back pay. Can leavers bring claims, and within what time scale? Questions.
Essentially, if you're bringing a unlawful deduction claim, you have to bring it within 3 months of the last deduction. So if someone has left and they've recently left, then yes, if they want to take issue with holiday pay, they could do so. As this issue has been going on for a number of years, there is some tribunal litigation out there where people have brought claims and they've been stayed, and some have been aware of the 2-year backstop and have brought multiple claims for different periods. So some people have been alive to the issue before, but if someone is coming to it afresh, they essentially have to have brought their claim within 3 months of the deduction.